FOIA, all persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-5108, Watkins Law Advocacy, PLLC, appellant versus United States Department of Justice, et al. Mr. Watkins for the appellant, Mr. Sani for the appellate.
Good morning, counsel. Mr. Watkins, please proceed when you're ready.
Good morning. May it please the court. This appeal is about 3 Freedom of Information Act requests, all with the same subject matter, involving the reporting of the names of veterans who the Department of Veterans Affairs has deemed to be financially incompetent to the Federal Bureau of Investigation under the Brady Act. The Department of Justice has essentially withheld all documents related to this subject matter. There are broad categories of documents that were requested from the Department of Justice, which is charged with handling the Brady Act. Yet, 7 years after the Freedom of Information Act requests were filed, 2 documents have been disclosed that are the annual reports provided to Congress. The scope of the FOIA requests clearly encompasses all of the annual reports that were provided to Congress to explain how names have been reported by the various agencies of the federal government under the Brady Act. That is just a piece of the scope of the FOIA request to the Department of Justice. The FOIA request to the FBI is quite similar in scope to DOJ. And then the third FOIA request is to the Department of Veterans Affairs. The Department of Veterans Affairs, unlike the other 2 agencies, has identified many documents, but withheld them all under deliberative process privilege, making allegations that communications between agencies, without identifying whether the communications were between attorneys at agencies, are still covered by attorney-client privilege. So the Department of Veterans Affairs is not at issue with respect to scope of search, but is at issue with respect to the applicability of deliberative process privilege. The problem here we'll start with the Department of Justice, is that in its response determination, in its initial letter, before it provided any information about documents, said, well, they said, sorry, we have unusual circumstances. And the unusual circumstances, apparently, from the Department of Justice's perspective, were that they needed to search for the documents elsewhere. There are only 3 circumstances under the statute when unusual circumstances apply, and they are the need to search for and collect from an office separate from the office processing the request, the need to search for a voluminous amount, and the need to consult with 2 or more components outside the agency. There's essentially an admission in the response letter from the Department of Justice that they needed to search beyond the Office of the Attorney General if they were going to pull the documents that were responsive to the request. There was no such search performed, it appears. All the evidence suggests that from documents that were not produced by the DOJ, there are many more documents that should have been uncovered.
Can I ask a question about that? So as I understood the back and forth in the district court, the government made apparent in some of its submissions that it understood the requests to DOJ to be one directed at the Office of the Attorney General,
yes.
OAG. And I didn't see where that characterization of the scope of that request was contested. And I know that you have some questions about why not look at some of the other components, why not look at Office of Legislative Affairs. But as I understood the back and forth in the district court, it was framed as a request to OAG qua OAG, as opposed to the Attorney General as the supervisor of the entire Department of Justice. And I didn't see where that framing of it was disputed by you, but maybe I'm wrong about that.
So the framing of the request must encompass the following. The request was made surely to the attention of the Office of the Attorney General.
Right.
For example, these annual reports that the Department of Justice is supposed to file with Congress about how many veterans have been reported under the Brady Act so that they lose their Second Amendment rights. There is no way for anybody to know who at the Department of Justice prepares that report. An insider to the Department of Justice might know this, but any member of the public would not. Before this lawsuit, not a single one of those annual reports had been disclosed publicly. After this lawsuit, we have one with a date on it, one without a date on it. The request specifically says if DOJ's OAG does not have custody or control over certain requested and responsive records, but knows or believes that another component of DOJ subject to FOIA does, please forward this FOIA request to the appropriate person and inform us that you have done so. That seems to fit neatly within unusual circumstances as defined by the statute. There was a perfect understanding at DOJ that OAG may not have had the documents. I'm not sure whether they do or they don't. What I can tell you is that although the OAG is charged with informing Congress about reporting under the Brady Act, there's no evidence to show that they have. I don't know who at DOJ does it, and I've had to wait 7 years to try to find out. I don't know what a FOIA applicant is supposed to do with DOJ.
Well, did you consider just filing a FOIA request with the Office of Legislative Affairs after this came up?
So this places the burden on the FOIA applicant to essentially pepper DOJ, every division at DOJ, with a FOIA request if you don't know where the documents are.
Well, you targeted one specifically to the Office of Attorney General, and you have reason to believe it's in a different office now. So I don't know that it has the consequences you're describing. I'm just asking, once you were aware that it could be the Office of Legislative Affairs, to which you had not directed a FOIA request, couldn't you have submitted one to them?
7 years ago, I didn't know where any documents were at the Department of Justice, let alone the FBI or the VA. I didn't know the scope of what I would be given. All I knew was that I had several veterans who I was trying to represent.
I know, I'm just talking about in the interim to try to speed things along here, because I understand your interest in efficiency here. So that's why I'm wondering if...
Is it possible that I could have filed a request directly with the Office of Legislative Affairs? Sure.
And once you discovered, I'm not taking issue with the proposition that you wouldn't have known that at the outset, but in the course of the back and forth in the 7 years that's transpired, it became apparent that OLA might have some documents at that point, or even now, a FOIA request could be submitted that targets Office of Legislative Affairs.
I agree. It's possible to still submit. I'm going to reserve the rest of it.
Can I ask you, we'll save you some time. I just had one more question. This is just a fact question. It's not to get into legal consequences at all, but are these reports, normally reports between the Justice Department that they're required to submit to Congress, are a matter of public record? Are these reports nowhere publicly available that you're aware of from Congress or from?
I'm not aware of any place that you can get these reports.
Very strange. Okay.
I'm not aware of any instance of them on the internet. The only instance is a recognition that in this lawsuit, one undated report and one dated report were revealed.
Right. Okay.
That's part of the
Very
problem.
strange. Yeah.
Right, 80% of the veterans who are proposed to be financially incompetent through the VA's process are deemed financially incompetent. That means that 80% of them probably had no lawyer who could help them, or they had dementia and they belonged in the category of being financially incompetent. But I can tell you from the perspective of somebody who represents veterans, it's very, very hard to defend them because the process is secret. And then it takes a half a decade before you can ever get to an appeal to try to reverse a financial incompetency decision. So the importance of these records could not be greater for these several 100,000 veterans who in a reasonable period of years were reported under the radio. Thank you.
Thank you. We'll give you some time for rebuttal. We'll give you some time for rebuttal.
Thank you. Just a few minutes. I appreciate it.
Mr. Simon, we'll hear from the government now.
Good morning. May it please the court. Shortly before this lawsuit was filed, 5 years.
Can you just make sure you stay kind of within the zone of the microphones instead of deviating to the side so it gets a little bit hard to hear?
Shortly before this lawsuit was filed 5 years ago, the OIP, on behalf of the Office of Attorney General, responded to Mr. Watkins, advising that the Office of Attorney General's record system was searched in response to his request. Mr. Watkins filed a complaint thereafter, in which he confirmed in paragraph 30, this is Joint Appendix 19, that the material he sought with respect to his FBI and OAG request concerned interagency agreements and the procedures by which information on veterans was reported to the FBI. In a initial round of summary judgment motion filed 4 years ago, the FBI stated that it understood the request to seek documents regarding the process by which the VA provided information. OIP on behalf of OAG made a similar statement. That's JA 211-212. In Watkins' response opposition and cross motion at JA 371, he had a very limited argument as to the adequacy of the search by OIP and FBI, limited to search terms used, and the omission of a document at the 1998 Memorandum of Understanding that had not been produced or located by the FBI, did not take issue at all with the understanding of the scope of the request or the OIP's determination that the request sought the records of the Office of Attorney General as the component to which the request was directed.
Does it ever happen that DOJ, so OIP is the intake valve. If OIP just learns that even though the search was targeted at OAG and that was said in the back and forth and that wasn't disputed, if OIP just learns, actually, that was just a mistake because I'm just hypothesizing, because really the bulk of the documents are in the Office of Legislative Affairs. Is it ever the case that OIP would just then ask OLA to run a search and to come up with the documents just because the government, who's in the best position to know where the documents might lie, discovers this and in kind of good faith with a FOIA requester just decides to do that?
Well, I think, Your Honor, there's a decentralized system at the Department of Justice in their regulations for a reason. Thousands, tens of thousands of FOIA requests come in, and there's an orderly process by which they are evaluated. At the intake stage, if the face of the request indicates that the requester sent it to the wrong place, if hypothetically this request actually said, I am looking for reports from DOJ to Congress regarding the NICS, then OIP would have referred the request to the Office of Legislative Affairs. Because OIP is the processing arm for that office, they would have then conducted the search of OLA records. But this request does not seek requests to Congress. And Watkins was aware in the 2007 NIC Improvement Amendment Act, it stated that reports will be made to Congress. So if that's what Mr. Watkins wanted, or what Watkins Law Group wanted, they were on notice that such reports existed, and they could have specified that in the request. Now, yes, the DOJ doesn't assume that a requester is going to understand necessarily that it's OLA that makes the request, the reports to Congress. And so had Watkins not known that, that's fine. If he had specified in his request, it would have been routed there.
Well, it's not just that he known. The government's own FOIA reference guide lists the type of documents the Office of Attorney General has as including specifically, quote, congressional testimony and accountability reports to Congress. It doesn't say the Office of Legislative Affairs would have, in its description of its content, it doesn't fit this type of report. And so the government's own guidance to FOIA requesters said he was asking the right place for a report from the Office of the Attorney General, putting aside the additional consideration that if it's a report from the Attorney General, even if OLA is doing the transmission, doesn't it beg our belief to think that the Office of the Attorney General doesn't have a copy of a report it sent to Congress each year?
Well, but to be clear, Your Honor, OIP did run a search. Its supplemental search using terms that Watkins had proposed, which was done during litigation, located sort of incidentally these reports to Congress.
No,
two reports
two
to
of them, but
Congress.
that's sort of the problem, right? If the Office of Attorney General is making these reports, the FOIA guide says they're the office that will have them. And it took a supplementary report search just to find two of them. Doesn't it almost res ipsa loquitur say there's something wrong with your search process,
well,
that you're not finding them?
Your Honor, the OIP then, after they found those two reports, used the words from the title of the report and ran those words in the database, the OAG database, and still did not locate any additional reports. So the question here is whether that was a reasonable methodology to try to find any additional reports that might be in the.
Have these reports been filed as required by law annually, or I think it later changed to twice biannually?
I'm not in a position to answer that question other than to say that the search done by OIP of OAG records using a reasonable search methodology, that is the titles or keywords from the titles of the two reports they did find in that database, did not locate any additional reports.
Is there somebody in the office that's in charge of making these annual reports? Who in the government is in charge of making these, drafting up? It's not the Attorney General himself. There's got to be somebody who's in charge. Was that person asked, identified and asked?
Again, the record establishes that what's reflected in the record is that it was the Office of Legislative Affairs that sent these reports.
Sent them, but that doesn't mean, again, I guess I would be shocked if the Office of Attorney General didn't have a copy of reports that it sent. They might have done the transmission, but these are from the Attorney General. I'd assume drafted by somebody on staff there, or put together, compiled by somebody on staff there. It's not the OLA's job to compile these reports.
Your Honor, again, this is in the FOIA case, the agency's obligation is to conduct a reasonable search. The request did not seek reports to Congress. Mr. Watkins took
So we can debate whether the request, in fact, encompassed reports to Congress. Let's assume that it did. It didn't do it by name, but let's assume that the contents of at least the third request were broad enough to encompass it.
And OIP conducted a search in the database that it determined was likely to have responsive records within the OAG, again, because the request was directed to the OAG. It located two reports, and then following that lead, went and did a supplemental search of the database using keywords from the title of the two reports that it did locate. And we submit that that is a reasonable search methodology to try to locate whether any additional reports existed. And the law is well settled in this circuit that you do not evaluate the reasonableness of a search based on its results, but on the methodology.
But it's not uncommon in these searches to also find the subunit or the individuals responsible for handling certain matters, having them check their files as well, but that doesn't seem to have been done here. Somebody's got to be writing these reports if they're annually filed with Congress.
Your Honor, this is an issue that was not, to the extent it was not developed below in the manner that the court's indicating, it's because Watkins raised this issue at the 11th hour in a final round of summary judgment briefing, where he recharacterized the request as seeking reports to Congress. And I will say, even then, never took issue with methodology used by OIP to search the OAG record. His argument instead seems to be that the request should have been read to seek reports to Congress, and that OLA should have been, the records of OLA should have been searched. And we would submit that Clement does not impose that obligation on them.
But here you have. Question, David?
No, you go ahead. I was going to change the subject.
Go ahead.
Tell me, are you done?
Go ahead.
I want to ask you about the Exemption 5 issue. So the government's obligation under FOIA is this is a quote, to correlate exemption claims with the particular part of the withheld documents to which they apply. That's the standard here. And when I look at the Vaughan Index and the declaration, what I see is, a broad assertion of attorney-client and deliberative process privilege without any, at least I didn't see any effort to correlate them to which document. Did I miss something in the record?
Your Honor is correct that in every column, the agency claimed both deliberative process and attorney-client. But what I would emphasize on the Vaughan is that the Vaughan in its totality is detailed in terms of the type of issues that were being assessed in connection with the development of the Memorandum of Understanding. And I'd like to direct the court to JA 670, which is it's a December 1997 internal memorandum of the FBI that was produced in this case, reflecting essentially
Which document number is this?
JA 670. It's reflecting the completion of the MOU development process.
Yeah.
It's stated that the each MOU has been reviewed by the policy and legal points of contact at the appropriate agency and their comments incorporated into the respective MOU. So it's clear that the documents, the ones from the 1990 time period that Watkins has identified, were all in the context of developing the MOU, identifying sort of issues or trying to develop a common understanding between the FBI and the VA as to what obligations there were under the statute in terms of what needed to be reported for inclusion in the NIC, and also consistent, though, with other statutory obligations that.
Then you think that's enough for us to conclude that, is that deliberative or attorney-client? Which is it?
Well, the process was both pre-decisional and deliberative in that it led up to the 1998 MOU between the FBI and the VA. And as to specific entries,
not all actions that lead up to a final decision are deliberative.
right, Your Honor, but
I'm just asking how we know that that's deliberative.
well, we know that
You're not claiming it's attorney-client, right?
I'm not claiming the district court determined that not all of the attorney-client designations applied, and so we're seeking affirmance of that district court's decision. So we're not asserting.
Well, let me ask you about a document or two then. Take a look at number 77. I'm sorry, I don't have the JA set. Number 77. It's a letter from the VA secretary to someone at ATF regarding comments to ATF on proposed regulations regarding definitions of persons prohibited from receiving firearms. Why is that?
7.
Yeah, sorry about that. Why is that attorney-client?
What's the document 77? Your Honor?
What's attorney-client about that?
I don't. I'd have to check the district court decision. I don't.
Well, we're de novo here. Just
no, I understand.
the record.
I don't believe the district court found attorney-client to apply to that document.
I was asking. it doesn't make any difference to me what the district court found. I'm asking you why that document is either deliberative or attorney-client.
Your Honor, I believe the designation for attorney-client was related to some markings on the document indicating that it had undergone review by the OGC.
Yeah, well, not everything that undergoes review by OGC is attorney-client. It still has to be about a legal question.
And I would just submit, Your Honor, that if the court does not believe that satisfies that's sufficient information to satisfy attorney-client privilege, it does fall within this deliberative pre-decisional time frame, which the FBI and VA work closely coordinating to come up with a memorandum of understanding in order for to comply with the Brady Act.
Take a look at. Were you going to ask a question about that document?
A different document.
Yeah, I was going to ask you about. Take a look at 90. I'm sorry, I don't have the JA. It's a memo from an undersecretary to the VA General Counsel. Okay, and no question. A letter from the client to the counsel could clearly be attorney-client, but there's nothing in the Vaughn Index or the Knight Declaration that says the VA secretary was seeking legal advice in connection with that document.
309. JF 309.
Yes, I see that, Your Honor.
Yeah.
Again,
you see my concern about this, of trying to apply the standard to this case. It's the government's burden to show that these documents are covered by an exemption, otherwise they have to be released. And I honestly don't see with respect to these documents and quite a few others where the government's met that burden.
Well, Your Honor, again, with the VA raised also the deliberative process privilege below, and we would submit that.
Okay, but how do I know? How do I know that's deliberative? See, the point is, without distinguishing between the two of them, obviously the attorney-client and deliberative process are two different functions, two different actions, and something could be deliberative without being attorney-client or attorney-client without being deliberative. And I just don't, to be honest, don't see enough in here to tell me which is which and why it would be, as we've said, quote, correlated to the particular document.
Well, Your Honor, I would submit again that the totality of the Vaughn is reflecting a deliberative decisional process leading up to the MOU. In fact, the request.
Well, that doesn't work for everything. So how about, as far as I know, so how about document 30? We can do this forever, but the way you've done this as an umbrella is to say that we ought to view this in context, and based on the JA 670, that everything before a certain date is pre-decisional. I don't know about that, whether we ought to read that into every single thing, but document 30, JA 298, table of contents by tab number, October 11, 2005, Brady Act, SVAC meeting, briefing book, table of contents. Does that mean that the 2005 is the relevant date for that one?
Well, Your Honor, yes, there are other obviously later dates after but for this one, it's deliberative, Your Honor, because it is what it is a table of contents of what was identified by someone to include in a briefing book for someone to utilize at a meeting. And so there is, I think, we cited the Applicable Case Authority where this court has recognized that separating information out is considered important for a particular discussion is a deliberative pre-decisional process.
I mean, there's that. All we have is there's nothing that would tell me that a briefing book table of contents is by definition deliberative process, or is that your position? Is that a position? That
I think this says it's in the context of a meeting, for preparation of a meeting, and it identifies the meeting date. So I think. So
any document that has to do with a meeting is deliberative process in the government's view.
No, but if you have a document that details out the specific documents that are included in a briefing book that is used to prepare somebody for a meeting, then I believe that satisfies.
Don't we have to know what the meeting's about?
I don't know that in the context of
we need to know it's about making a decision. We can't assume just because something happened in before a certain date that it was about that decision, about any particular decision.
But
You have to identify the decision that this is supposedly informing. That could be a retrospective. That could be describing things. That meeting could be discussing things that are already a matter of public record.
well, the subject matter of the meeting is identified, and it is a.
And the subject matter is?
It says the SVAC meeting. I don't know what those.
You don't know what SVAC
So
means?
if you don't even know what it is, then it's a little bit hard to identify. I'm sorry.
You go ahead.
What the decision possibly could be.
Well, but it's not, I think the courts recognize it in the deliberative process. There doesn't need, if it's part of a decision-making process, in other words, a meeting, preparing somebody for a meeting.
Any meeting.
Well, a meeting.
What's your best case for preparing somebody for a meeting?
This is clearly related to the request here. It's the context of the request creates the parameters here. Watkins sought information in his request to the VA regarding the approved, see what his language was, decision-making procedure.
He had a very broad request. Yeah. So.
Well, to the VA, approved decision-making procedures to determine whether names will be reported. So that's the parameters of what these documents relate to.
But if the decision had already been made, and now they're having a meeting discussing the decision that's already been made, that's not going to be pre-decisional.
But the deliberation that went into identifying the records to brief somebody, to prepare somebody for the meeting is a deliberate. Just like if
Again, we don't know what this means.
Just like the records I reviewed to prepare for this oral argument.
But you could have an after-the-fact debrief. Government, I mean, when I was in the government, we did that sometimes. And I think it's just a standard thing for organizations to do. That's a post hoc debrief. That's a meeting that often happens, but it's not with an eye towards a subsequent decision. It's with an eye towards something that already happened.
Well, again, I would just analogize to the process, for instance, which I prepared for this argument.
Can I just ask you, with every one of these documents, the last column says deliberative / attorney-client privilege. I take it the slash is and, not or. In other words,
yes,
this was claiming both privileges for every document.
That's correct.
And what's the possible attorney-client privilege specification for that one?
Your Honor, it doesn't state in this entry what it was. The district court only upheld it on deliberative process.
But the government claimed attorney-client privilege in the bond index in withholding the document.
That was a claim by the VA, yes.
Yeah. And what could the basis for that be? Wouldn't there need to be some elaboration of how this could fit within the attorney-client privilege?
These are all records from the Office of General Counsel. And I think that is.
But it can't be that. I mean, I can't imagine you're taking the position that every document that was within the purview of the Office of General Counsel is protected by the attorney-client privilege. That obviously can't be right.
Well, I would say the other thing I would do, Your Honor, is refer the court to JA 283, which is the Knight Declaration, where the court, where the declarant stated that the basis for the attorney-client claims.
Right, and as I read that was just a definition of the scope of the attorney-client privilege, which I think it was right. If you look at Black's Law Dictionary, I think it adequately says what the attorney-client privilege is, but it doesn't tie the attorney-client privilege to any particular document, including, for example, this one, which just the whole purpose of this is supposed to be so that the court can make an intelligent and informed assessment of whether the withholding based on a particular privilege is supportable. And with some of these, it just seems difficult to say that the record is sufficient for the court to make that kind of assessment.
I think the court also needs to give some consideration that these are very old records. And so recreating exactly, what the specifics were of the specific circumstance of the specific meeting over 10 years earlier is a challenge that FOIA doesn't really.
Well, that's definitely true, but the burden's on then if it's a document that actually is responsive, then the burden's on the government to explain why it's not turning it over. So if there's difficulty with old documents, it seems to me that falls upon you as the government to explain, notwithstanding how old it is, why it is that it shouldn't be turned over. Otherwise, the document gets turned over.
And I would just, again, reiterate that the alternative of delivery process provides an alternative basis for the court to affirm. In fact, that's how the district court evaluated this particular document. Unless the court has other questions, we would.
I have one. There was Department of Veterans Affairs somehow discovered documents that had bureau file numbers in them that the FBI itself did not discover until it found the Department of Affairs had it, went back and found those exact ones. But nothing in the Hardy Declaration tells us when the FBI, after the VA uncovered these things, went back and found them, where it looked to find things that it hadn't found in its own search and why it hadn't found them. And isn't that a pretty fatal flaw? Because they had documents, the VA found the documents, and the FBI quickly and easily found them once the VA gave them the document number. But we have no explanation, again, as to why they weren't found in the first place by the FBI. What was wrong with the search that it missed them?
Well, but again, to the extent the court finds there was a deficiency in the original search, the FBI cured that with a supplemental search by taking on its own initiative to utilize information from the VA production that allow it to more readily target what was in the archived files.
What did it do to find these? Why didn't it find the files the first time? What did it do to find them this time? And in its supplemental search, and why didn't it find them the first time?
The supplemental search is described in JA 587 of the Second Hardy Declaration, and by having file numbers, they were able to then locate the files. As I understand,
FOIA requesters can't provide file numbers, so there must have been something in those words that was missed by the word searches that should have been caught. And so, did they rerun searches with new words rather than just look for those two file numbers?
The search that was done relating to these documents was done at the division of the FBI that houses the NICS. And the individual who...
did they just look for the file numbers that the VA had discovered, or did they do a broader search in their supplemental search?
The supplemental search utilized the file numbers that
That's
were
it.
apparent. That's according to the Hardy Declaration.
But there clearly had been something that the initial search missed. And so rather than do... Normally, a supplemental search puts in additional terms. Here, they just put in the two file numbers, but made no effort to discover if there were other files that should have been uncovered. How is that sufficient?
This particular search, Your Honor, was of the archived records. It was not done electronically. It was done with archived records by the individuals at the NICS knowledge. It's the CJIS, as it was called, the division within FBI that houses the NICS with knowledge of the records maintained by that agency. So that is the location they determined was reasonable to search for this. Again, Mr. Watkins,
I just want to clear. Here's what I'm missing. I understand that, but all they did was go look for these two file numbers instead of doing a search that would have found related files, because clearly the first search missed those documents. So it's old. You should have searched the archives to begin with, but there was no.
The archives were reviewed initially.
Well, then how were these missed?
I don't know how they were missed, Your Honor, but
don't we need to know that? Don't we need some explanation for what went wrong?
Again, it's the methodology. They used file numbers that actually uncovered the very documents that Watkins said were missing, on which he based his claim that the FBI search was deficient. So having found those records, and I think approximately 50 or 60 pages of records, that actually validates the reasonableness of the FBI search. Under the Miracle case, they found additional documents actually locating the records that the requester said should have been found in this first.
Make sure my colleagues don't have additional questions for you. So,
thank you. I ask that the judgment below be affirmed.
Thank you, Mr. Simon. Mr. Watkins, I think you had 2 minutes left for rebuttal.
Thank you, Your Honor. 2 points. The FOIA request to DOJ was quite broad. All records, including all amendments, supplements, exhibits, and addenda thereto, which set out or reflect the providing of information such as names of individuals, by the VA to the DOJ/FBI for inclusion in the National Instant Criminal Background Check System, known as NICIS. It was a broad request. It wasn't meant to only encompass annual reports. It was meant to encompass much more. The request is similarly broad to FBI. FBI in its supplemental search found 59 pages of documents. Through 2015, 260,392 veterans' names were reported by the VA for inclusion in the database of individuals not entitled to have a handgun under the Brady Act because they were deemed financially incompetent. 260,000 individuals. In 2017 to 2018, 50,000 veterans were reported. How is it possible that they found 59 pages of records when the FOIA request encompassed all records which set out to reflect providing of information? It's just not plausible. It doesn't meet the ancient coin standard of being sufficient. There's so much material out here. It's overwhelming.
What do you think is missing? We know the congressional reports.
I think everything in modern times is missing. They found a single document in the past decade about the transfer of names between the VA.
Well, you didn't want. You said you didn't want the ones. Presumably, there's papers that say X name, add this to the list. X name, add this to the list. But you didn't. You just claimed wanting those individual ones. So that presumably there's a large volume of those, but those are not encompassed by your request.
I understand, but there is cooperation between the agencies. They're not on autopilot. They have to talk to each other over all of these years worth of time with tens of thousands of names being reported each year. It seems completely implausible that every document in the last 10 years lists particular names in it. That's not how they transfer information. They send the information electronically, whether it's on a CD or over the internet, whatever they're doing today. The memorandum of understanding that we have obtained through this set of FOIA requests, they explain that they're allowed electronic transfer. But the real point is that they have to coordinate with each other. The memorandum of understanding have changed over time. It seems only reasonable to conclude that there are far more documents between these agencies than have been admitted to exist. As a last point, cutoff dates. We've waited 7 years for documents in these cases. It simply is unfair to go back in time and to use a really early cutoff date. A FOIA requester is kind of stuck in the process, right? The agency says, here's the date that you get. It's the date that we performed our search, even if it was a bogus search. It's fundamentally unfair under the statute to expect a FOIA requester to get stuck with that early date when it didn't perform, when the agency didn't perform a proper search. Thank you for your time.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 21-1139 et al. Waterkeepers Chesapeake et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Pugh for the petitioners, Mr. Ediger for the respondents, Mr. May for the intervener, Maryland Department of the Environment, Mr. DeBruin for the intervener, Constellation Energy Generation LLC, Mr. Bees for the respondent, intervener, Department of the Interior.
Morning, Mr. Counsel. Mr. Pugh, please proceed when you're ready.
Right. James Pugh for petitioners, Waterkeepers Chesapeake. Lower Susquehanna Riverkeeper Association, Four Rivers, and the Chesapeake Bay Foundation. I'd like to reserve 3 minutes for rebuttal.
Did you raise the podium as high as it'll go? Or you did? Okay, got it. Good. Just making sure.
This case is about the health and the future of the Chesapeake Bay and Susquehanna River. Federal Energy Regulatory Commission has issued a new 50-year license for the Conowingo Dam, and that license does not include the water quality certification that Maryland issued for the dam or any of the important requirements that Maryland established as necessary to protect the dam, protect the bay and the river over the next 50 years. FERC violated the Clean Water Act by issuing the license without the certification. It also acted arbitrarily and violated the Federal Power Act and the National Environmental Policy Act by failing to give adequate consideration to the harms that its decision will cause over the license. And I'd like to address those issues in that order. The Clean Water Act provides that no license shall be granted unless a water quality certification has been obtained, in which case it must be included as a condition on the license, or water quality certification has been waived in the specific way that Section 401 of the Act provides. That way is that the state must have failed or refused to act on the certification. FERC, the Federal Industry Regulatory Commission, I'll call it FERC, that's all right. FERC agrees that Maryland acted on the certification. It acted in 2018 by granting a certification. At that point, this is positive because Maryland neither failed nor refused to act on the dam owner's certification request. It did not waive certification.
Does that trigger at the moment that the certification is made? Is it a gotcha game? I mean, suppose you have a situation in which there was just a mistake, and the state administrative body realizes it sometime later, several weeks later, and says, "Oops,
well, there's
a mistake."
There is a process that first there's an administrative process at the state level, so the state can and often does reconsider its decision in the rehearing process.
And what about that? So there's a state administrative process. There's also state judicial review. So there's things that can happen in the state's own processes that result in annulling or vacating a certification that was issued. I take it you don't dispute the proposition that those things count, even though the certification was granted.
Oh, no, I agree. Those things count.
And how does that? How do you square that with the statutory text?
Well, once a certification has been vacated or withdrawn by the state, it doesn't exist anymore at that point.
But why does the state get to do that? Why?
The certification, the state gets to decide what happens with the certification. The state gets to issue the certification, decide what goes into the certification, and it can withdraw the certification or vacate it under its own processes. What FERC has to do, FERC's job is issuing the license. And what the statute says is FERC can issue the license unless certification has been waived in that very specific way. So that's the statutory context.
So in the circumstance in which a certification is issued, but then it goes through state administrative review and the decision is made by the state to, what you called it, withdrawing the certification? Or
vacate it, as the state did in the FPL case in Maine.
Or vacate.
So, I'm not sure what they may use different words, but essentially make it disappear. State yes.
And that's okay under the statute because what are the words that say that that's okay?
Well, the Clean Water Act simply doesn't address that. The Clean Water Act is talking about FERC's authority and the limitations on that authority. It doesn't talk about what the states can do with certification.
And then if that's true, then why can't the state do what it did here?
Well, there are two reasons for that. One is under the Clean Water Act, a state that wants to change its mind and withdraw a certification, if that's presuming that's what the settlement does, and we'll get into that in a minute, whether it's forced to do that. But if that's what it wants to do, it still hasn't failed or refused to act on the certification. And Congress is very specific that that's the only kind of waiver that gives FERC authority to issue a license.
But why is I'm just missing something, so forgive me. Why can't everything you just say equally be said about the situation in which the state itself decides to withdraw because the certification doesn't survive administrative review? it's still a decision by the state to take back something that it granted.
Once a state, say a state has withdrawn an existing certification, at that point, the project owner can apply for a new certification, and the state can do all the same things it could do under the statute as if none of that had happened. It could waive, grant, or deny. If it waives at that point, it is properly waived, and FERC would have authority to issue a license. But
so the difference is between waiver and withdrawal. So
right, there's a big difference between waiver and withdrawal.
So here you think the state could have withdrawn it based on the settlement?
Well, it would have had to go through its own process, and frankly, I think it would have had a very hard time explaining in that process why it suddenly decided that all the things it found necessary to protect the river and the bay were not necessary. But yes, it could have gone through that process.
It could have done it.
Yes.
And then that wouldn't be a waiver. That would be a withdrawal.
That would be a withdrawal.
And from your standpoint, and that's not a question of federal law. It's a question of state law, whether the state adheres to its own processes in effectuating the withdrawal.
Yes.
But if the state does that, and that's okay, then then FERC doesn't have to issue a license at that point.
If a state goes through that, right, if the state goes through the entire process, withdraws, the applicant reapplies, and the state then waives its authority, the Clean Water Act is satisfied.
And you think, and just sorry, there's one more follow-up. You think that in the circumstance in which a state, as a matter of administrative or judicial review, decides that the certification was erroneously issued, then that it doesn't take effect just sort of as a matter of by operation of state law, that the state has to follow some process to actually withdraw the certification apart from just vacating it as a matter of judicial review?
Right. The state court can vacate it, or the state in the administrative process can withdraw it. Both of those things are possible. But the end result of both of those situations is simply that there is no certification.
Okay. And so in this case, for example, if the state had a process under which it allowed for settlements like this one, and then it allowed for vacator of the certification upon settlement as a matter of state processes, that would have been fine.
That would have been fine. You'd still end up with a situation where there was no certification, and it would be up to the state to then either waive, grant, or deny.
Right. It takes you back to square zero, but that would, okay.
Well, I'm just confused about your after square zero. So say company X applies on January 1 for certification. March 1, it's issued by the state. And it's subject to internal review, evidentiary hearing, these types of things. October 1, through its own internal processes, the state goes, whoops, we totally messed up. This is an indefensible certification. We've got to withdraw this. And then nothing happens, and now it's January 1 of the next year. Why can't then the company that asked for the certification go to FERC and say, a year has gone by, they never issued a certification, let's proceed to get the license? They didn't act. They didn't issue, because the act that the statute talks about is issuing a certification or not. And it's not took some baby steps towards issuing a certification, took some tentative steps, either they issued a certification or didn't. They didn't under my hypothetical. Why isn't that sufficient to go get a license from FERC? You keep saying they have to apply and start all over again. I don't get that part.
I want to make sure I understand the hypo, because in October, the state is recognizing that it messed up.
Yes, it tears it up and throws it in the garbage
Right.
can.
Presumably, it doesn't just tear it up. It also issues a decision in that rehearing process that it is withdrawing.
No, not in my hypothetical.
Okay.
Let's say their administrative process is like a mediation process. And I go, oh, you're right, we totally messed up. We're going to pretend it never happened. They aren't saying anything publicly other than it's been withdrawn. And they can say that publicly, it's been withdrawn.
If they want to say it's withdrawn in that administrative process, then they're withdrawing it. Whether they've withdrawn it, adequately.
Yes, so they've said it publicly, it's been withdrawn. I'm not going to say they give the reasons. That's a matter of state law. And then I understood you to say is then the company still has to apply again for a certification. I don't know why they can't on January 1 or 2 of the next year go, we asked for a certification on January 1. A year has elapsed and we have nothing from the state. Go ahead, FERC, issue the license.
I think I understand the hypo better now. And I think that would be that there is at that point a withdrawal. The state has withdrawn this, unless I'm not.
Well, the statute doesn't talk about, the federal statute doesn't talk about withdrawals.
I just meant that what I thought was happening in your hypo is that the state was withdrawing the certification.
Yes, the operative fact, I guess, as I understand the hypothetical, and you're much more expert than me, is that a year has elapsed and there's no piece of paper from the state.
If they're right, if the state does nothing, I suppose there might be.
Does that process I've described count as the state doing nothing?
Well, I'm not entirely sure what, I mean, it sounds to me that process sounds like the state withdrawing the application. I'm sorry, withdrawing the certification. But if I'm wrong about that,
I'm not understanding the magic words state withdrawing the application. That seems to be what you find magical. Is withdrawal of the application something in the federal statute?
No, that's not a matter of
so that doesn't matter. Okay, so why does that matter? Maybe it matters under state law and they can have a state law litigation. But from FERC's purposes, the company says, I applied January 1, 2021. It is now January 2, 2022. And I've got nothing from the state. Issue your license. What is wrong with that? Under the federal statute, not state law.
Right. When you say that you've got nothing from the state, if there was truly nothing from the state, then that
under my hypothetical.
Okay, right.
You've got no certification from the state.
Well, there's a difference between no certification and a waiver. If there's no certification, there's simply no certification. That means that the parties are back to zero. What
do you mean the parties are back to zero? If there's no certification, why is that not a failure of the state to act? That is, to certify or make a decision not to certify for purposes of FERC. I don't know why FERC can't say a year has gone by and the state has declined to issue, has refused or failed to issue a certification.
The choices that are the options that are available to a state in that review process include withdrawing certification.
What do you think FERC's supposed to do when that company comes to them on January 2nd and says, the state has either refused to act or failed to act because I've got no certification, please issue the license? What is FERC supposed to do?
Well, if the state has withdrawn the certification, as it did, for example, in the FPL case, where Maine went through the administrative process and said, we're vacating the certification.
Just please answer my question. What is FERC supposed to do?
FERC is supposed to say there is no certification. We can't issue a license. If you want a license, ask the state for certification. You don't have a certification, but you also don't have a waiver. The state withdrawing a certification is not the same as the state waiving certification. And the big difference is,
why isn't it?
The state.
What if on the, but if in their withdrawal they said, oops, this never should have happened, big mistake on our part. We were thinking of a different case. We had the wrong case number.
And we're withdrawing it. That's right. So that certification is gone, and the applicant then has two choices. It can apply or not apply, and the state then has all of its choices. It can grant, deny, or waive.
What in the federal statute says they have to apply again, as opposed to saying the state has failed to act on our certification request? It's gone nowhere for a year.
Federal statute just says FERC lacks authority to issue a license unless the state has waived in a very specific way, which is
failed to act.
And withdrawing a certification is not the same as failing to act on a certification. Because the state has necessarily acted on the certification by granting it in the first place.
But wait, a refusal to act, a piece of paper that says we refuse to do this is an action.
Correct. No, actually, no. That would be what EPA calls an express waiver, but what the Environmental Protection Agency,
which is an action.
If the state writes a letter, say the state doesn't want to just wait for a year and let the waiver happen on that. It wants to let the project move forward on the second day. It can write the applicant a letter and say, we're waiting certification right now. But what EPA explains in its regulations, in the preamble to its regulations implementing Section 401, is what that means is the state is saying we're choosing not to act.
Which is a refusal, because the statute says fails or refuses to act.
Yes.
And there's got to be something that's a refusal that's not just a failure. And an affirmative indication by the state that we actually are not going to go forward with the certification is a refusal. You can call it an express waiver, but it's a refusal. That's where it fits in textually.
Could you rewind 5 minutes and finish explaining what happened in the Maine case?
In the Maine case, the only point I wanted to make is, and this is the FPL case, I think it's cited in Constellation's brief and also mentioned. Yeah. The certification was issued, and Maine then withdrew it in the or vacated it in the administrative process. I simply wanted to provide.
Then what happened after that? Do we know? So at that point, when Maine withdrew the certification, could the applicant, what would have happened next?
Actually, I'm not exactly sure what happened next in the competing cases. What I would say is what the applicant could do is simply reapply.
Reapply.
At that point, it had no certification.
Okay, because so the withdrawal, the vacating of the certificate also essentially vacated the application. So the clock's no longer running, right?
The clock starts. Right, the clock's no longer running.
So the clock starts over again if the applicant files another application for a certificate, right? Okay, great, thanks.
So it counts as I mean, I understand it's a little bit odd to say that what we're calling an action and then a retraction of that action, which means there was no action, actually was an action. That's where we are, right?
Well, I agree with that, and I would add that the original action is action enough to preclude FERC from issuing a waiver based on a failure to act. So once that certification has been issued, there cannot be a failure or refusal to act. There has been action. That history cannot be changed. It doesn't mean that states are handcuffed. They can't fix the problems. It just means they have to go through their own process and vacate the certification if that's what they want to do. And then the process.
Now, even our cases say at some point it can't be that the withdrawal of action ends up being gamesmanship that just extends. That gets into the.
If it strays into gamesmanship, then the Hooper case would come into play.
So when they withdrew, they said, we're withdrawing this and we are now waiving our right.
Not here, Your Honor. They never.
No, I'm just saying if they said, we're withdrawing this for whatever reason or no reason, and we are waiving our right to issue a certification in this matter, what would that be?
They couldn't do that, Your Honor. What they
can't?
I mean, waiver is something very specific under the Clean Water Act. It has to be a failure or refusal to act. So they could withdraw, for sure.
Why isn't it a refusal to act when they then add a next sentence that says, and we're hereby waiving?
Because
we refuse to act on this matter.
The refusal to act has to be on a certification. Just by adding that sentence in a withdrawal, doesn't mean they refuse to act on the certification in the first place. They did act. They had to have acted because they issued it.
They can't change their mind. Is what you're saying. There's no way they can change their mind on the initial certification. They have to wait for a whole new, initial application. They have to wait for a new application.
That's right. They have to wait for a new application. It doesn't mean they can't change their mind. It means there's some process that they have to go through. But that's entirely.
Well, where does the federal statute say? What language in the federal statute says they couldn't say we're withdrawing it and we are hereby affirmatively and expressly telling you that we refuse to act on this matter, on this application?
Because that withdrawal, once the state has acted on the certification request, the action on the certification request that matters, not just any action, an action on a certification request. And if a certification exists, it can only exist because the state has in fact acted on the certification request.
Now, I suppose the state could build in contingencies so that the state could say, we're issuing a certification, but every certification is subject to a period of 30 days to make sure that it was actually appropriately issued. And if that contingency is built into the state certification process, then you wouldn't say it's a one-way ratchet such that once they issue the document, it can never be retracted in a way that gets us back to square zero, as opposed to getting us to the point that you say, which is that's actually still an action, the withdrawal is still an action, and so you need a new application for certification.
I think that's right.
Okay. Can I ask you, sorry, Judge Tatel.
No, you go ahead.
You sure?
Yeah.
I was going to switch gears a little bit, and which is suppose just for argument purposes, I know we're going to hear an entire slew of arguments about why this premise is wrong, but suppose that we were to agree with you on this argument under 401. Why is the consequence of that not simply vacator of the license, as opposed to what you're asking for, which is not just vacator of the license, but actually imposition of the conditions that were in the initial certification? That's just not something that's standard administrative law for us to do something beyond the standard vacator.
I agree, Your Honor. And the waiver argument itself wouldn't lead to an order directing EPA to issue a license with the certification. The reason we make that argument is that the settlement, whatever it purports to do, doesn't withdraw the certification. It says Maryland is waiving its rights to issue certification. That doesn't change the fact that there is an existing certification out there. And Section 401B of the Act says that any certification has to be incorporated into any license. So it's a separate argument. We would be happy if the court vacates the license, but we think that because the certification was never properly withdrawn, the law requires it to the license.
So you think the consequence of vacating the license is that the certification that both parties assumed was no longer in effect, actually by operation of federal law, or for purposes of federal law, remains in effect such that FERC has no choice but to issue the license based on the conditions in that original certification?
It is possible that the state could continue its review process. Now, it's important to remember that Maryland and the power company and the dam company abandoned the state review process before it ever got anywhere. And so it is possible that they could continue that process. But we think that, yes, this, as of now, there is an existing certification and it should be included with the license.
Well, but see, that's interesting. Just to pursue the Chief Judge's question, if, as you request, we not only vacate the license, but direct FERC to issue a license consistent with the 2018 certification, if we do that, then what process is left for Maryland? The license has now been issued. Can they still do their normal procedures, whatever they are, reconsider the underlying certificate? I wouldn't think so, right?
If the court orders them, if the court orders FERC to add the license, no, I think that would be the end of the process.
Right.
Again,
so the only way FERC would, the only way Maryland would be able to invoke its own procedures to reconsider the 2018 certificate properly would be if we limit our relief to vacating a license, correct?
Yes, that's correct.
And I see. And would that, why wouldn't that satisfy? I understand that doesn't give you everything you want, right? You want a license with the 2018 conditions in it, correct? Yeah.
It would be very, it would be very good relief for the petitioners. It would be even better to have those protective measures in place.
But I guess what I'm asking is, since we know Maryland, the whole purpose of this statute was to give the state, put the state in the driver's seat, right, on these kinds of cases, right? I mean, that's what the purpose of this was.
I generally agree with that, Your Honor, but I think it's not the whole purpose. The purpose is also to protect.
The primary purpose was to protect the water. Point well taken. But it was to give the states a primary role. So given that, wouldn't we, and given that we know that Maryland now has some concerns about the 2018 license, wouldn't it be, to balance all these together, wouldn't it be better for us, assuming we agree with you about the statute, to vacate the license, which leaves Maryland in a position, if it wants to invoke whatever administrative procedures it has to reconsider the certificate, and which you agree it could do in another case, and ultimately decide that to withdraw the certification and start over again, right? That would leave the state, that would still leave the state with a semblance of authority under this statute, which it clearly has, right?
Yes, sir. If I can add one.
Otherwise, if we do it your way, we cut that off, correct?
Pardon me?
If we do it your way and vacate an order for it to issue a license based on the 2018 certificate, we cut off Maryland's authority under the statute to reconsider the 2018.
Yes, that's right. If I could add just one more point on remedy, the Department of Interior has asked that if the license is vacated, it would like to leave the fish-way prescription, sever and remand. I believe sever and remand the prescription. We don't.
How would we do that?
I don't know.
That one. All right. Well, maybe they can tell us how they think we can do that.
We'll give you some time for rebuttal. Thank you, Mr. Pugh. We'll hear from Commission Counsel now, Mr. Edgar.
Your Honor. May it please the Court, I'm Scott Edgar for the Federal Energy Regulatory Commission. Thank you for hearing the case today. I want to make some broad points initially about this, and it going exactly to Judge Tatel, your point about.
Could I just trouble you to just lower the podium a little bit just to make sure your voice comes through, or shift the mics just a little bit?
Indeed, we do agree that the purpose of the Clean Water Act, a big characteristic of the Clean Water Act, is to put the states in the driver's seat when it comes to enforcement of water quality standards in the country. To that end, the most obvious explicit expression of that is 401 itself, which gives the state this incredible power to veto a project. We think the Commission's interpretation of 401 has honored that. The petitioners here are relying on language in 401A, which discusses one type of waiver, which is waiver in the instance where the state doesn't act.
But it doesn't say waiver. State waives its authority, including through waiver or failure to act. These are the two kinds of waivers. There's nothing. I know that the argument in your brief is it doesn't preclude Maryland from doing what it did, right? Because it isn't excluded. But that isn't the way we read statutes like this. I mean, if a statute said, an agency can issue three kinds of licenses, A, B, and C, we wouldn't say that, well, it doesn't preclude D, and therefore that's okay. It isn't that this case. It says very clearly, it says, no license or permit shall be granted until the certification has been obtained or has been waived as provided by the previous sentence. I mean, that's pretty specific that Congress is saying the waiver has to be as provided in the previous sentence. And there's only two ways to waive it. So I don't see where we get the flexibility to say, well, there's a third one because it isn't excluded.
Let me try to I think you've presented me with a hypothetical that it's a negative implication. Because certain things are provided, then you can't do the other. And as the Supreme Court pointed out in the Marks case, that argument can make sense, but it doesn't make sense if we can't conclude that Congress thought of the unnamed thing, that is the general rule that any person can waive their statutory right. We have to conclude that Congress thought of that general point and intended to prohibit it.
I'm sorry to interrupt, but so what would we do? We would look at congressional reports to find out.
Yes, Your Honor.
But that's not the way we interpret statutes anymore. I mean, we're looking at the language of the statute. And, we don't have very many. We don't deal with a lot of clear statutes. But I honestly, I'll just tell you so you'll know where I'm coming from. I just don't see where with the language in this particular statute where it says no license shall be granted until the certification required by this section has been obtained or has been waived as provided in the previous sentence. I don't know where we would get the authority to say, well, going back to my hypothetical, there's no evidence in the legislative record that Congress thought the agency might do option D, so now we can do it.
I think we could look at legislative history and conclude that language was intended to prevent a state from dilatory action. And so that's the kind of waiver that's
Okay,
discussed.
wait, I'm sorry. I just want to keep this thread going. So if we found a Senate report here, or say someone stood up on the floor of the House who voted for this thing and said, okay, well, no, let's stick with the report because that's strong legislative history. And the report says, yes, there's these two ways to waive, but the Congress in enacting this does not intend to preclude the state from working with the operator to come up with an alternative certification. That would be enough?
I'm not sure I follow the hypothetical. I think that the two types of waivers are completely different things. One, the waiver that we're talking about expressed in 401A is waiver intended to force the state to act. And by not allowing the general form of waiver, you would actually have you would have a contrary outcome. You'd be thwarting the congressional purpose here.
Could you have a waiver after the state review already happens and actually ratifies the certification? Suppose the review gets completed and all the challenges to the certification fail. And then the state says after that, actually, you know what? We're waiving.
I think that's a harder case. I think
But if the statute doesn't, as I understand your textual argument, the statute doesn't preclude other kinds of waivers, including this is a waiver. This is a waiver after certification. That's what kind of makes this one. I think it's the linchpin of their argument. So what's to stop that from happening?
I think this gets harder as we go along. I think one important roadblock would be the issuance of the license. I think as long as the waiver.
Right, but FERC just waits. So here they're going to wait out. The commission's going to wait out the state review process. That's what was going on here anyway. And so the commission just waits, and then the state review process ends. The state review process ends in a ratification of the certification. In other words, a rejection of the challenges. And let's just suppose that there's just new composition of the state comes in and says, should never granted that certification. We waive it.
I think it would be available, and I think that the proper recourse and the recourse that should have happened here would have been to challenge that action in the state court and argue that it's arbitrary and capricious or something to that effect. And then the experts on the state water quality standards could take a look at the action and whether or not waiver violated state laws.
Well, if we vacate the license, that process can go forward, right?
It could. I think
as long as we don't do what Waterkeeper wants, which is to order FERC to issue a license based on the 2018 certificate. If we just vacate the license, Waterkeepers conceded that the state can still reconsider all of this, right?
That should have happened already, and it didn't. Waterkeepers had an opportunity to.
But Waterkeeper was relying on the statute that said there were two ways to waive it. Why did it have an obligation to do anything else? Let me ask you a second question about your theory. What language in the joint settlement do you think actually acts as a waiver? What is the language that does that?
I believe it's section 3.2A1.
Why don't you read me what you think is the best language?
And that's the language that.
Sorry, what?
That's the language where the state says that it waives its right to issue a water quality certificate.
Mm-hmm.
You know where that is in the JA?
Let's just read it, would you? Yeah. Find it and read it, please.
Yes. 3.2A1
JA what?
Sorry, JA 626. As set forth in the offer of settlement, the state of Maryland shall waive its rights to issue Clean Water Act Section 401 certification in connection with the new license.
Is that the end of the sentence?
It goes on to define that action as a conditional waiver.
Well, that was my point. What's a conditional waiver?
Here,
It says this is a conditional waiver. Again, we're back to the statute. If the state itself, the statute says waiver, and what the state has done is issued a conditional waiver. So even if your theory is correct, has it really waived in accordance with the statute?
I believe so. And I believe that the waiver became complete upon action on this document, the settlement that was filed with the commission. This is conditioned on approval of the proposed license measures.
But that's not a waiver. It's not waiving its authority under the statute if it's saying we'll waive it so long as you accept our conditions. Again, see, it's another example of where you're departing from the plain language of the statute. So aren't you? I don't need to state it as a firm. That was a question.
Well, we don't believe that.
That was a question.
We don't believe that this language is plain. The Congress hasn't addressed the issue of whether a state can affirmatively waive, and EPA has interpreted this language as permitting affirmative waiver. This court in Alcoa Power.
The statute says you can refuse to waive, which is what an affirmative waiver is. I don't think the statute's silent. You can waive by failing to act, or you can refuse to act. Wouldn't that be enough? Wouldn't refuse to act include an affirmative waiver?
I don't think so, Your Honor. I don't know.
You hereby announce that we refuse to act on this? That's not a waiver?
I think the rigid interpretation that's being advanced here by petitioners.
No, I'm just asking you my question. In response to this, you were relying on the ability to do an express waiver in response to Judge Tatel's question, but I don't think that's any gloss on the statutory language, which includes refusals to act. Refusals require some expression. I
don't think that's the natural consequence of what petitioners are advancing here. I think the language.
I was just trying to understand your answer to Judge Tatel, where I thought you were saying that it requires a gloss on statutory language to allow affirmative waivers. Did I misunderstand you?
I don't think so. I think what I'm trying to say is that the statute doesn't permit the affirmative waiver here that EPA says is possible. And as this court said in Alcoa Power, that a state waive.
The statute doesn't allow the affirmative waiver that Maryland did here?
I'm saying the arguments advanced by petitioners suggest that would not be permissible. And as we can, the commission cited the EPA website, the commission cited the case from the Northern District of Mississippi, 1980, and this court expression in Alcoa Power, which stated that a state waive in the during the state administrative process.
Can I ask you one question? I just want to know whether the commission has a view on this, and we can ask the parties to the agreement too. But if we were to vacate the license, is the settlement agreement still in effect because FERC did issue the license, thereby satisfying the condition that was set out in the agreement?
I think there are a lot of moving pieces here, and I think Your Honor raises a good question. I don't want to get ahead of the commission on a question like that, but I think that's an important piece of this, is that there was a part of the settlement was the acceptance of the licensee's withdrawal of the petition for declaratory order based on Hoopa Valley. And that posed a significant risk to the state because they stood to possibly lose any entitlement whatsoever to make any conditions whatsoever. And it's not clear to me how that would play out.
So from the commission's perspective, the commission's not in a position to say what the direct consequences of a vacator of the license by us would be.
I think that's right. We would have to, I wouldn't want to get ahead of the commission on that question. And for that reason, according to the Allied Signal factors, we strenuously urge this court to consider remand without vacator.
Without vacating the license?
How can we do that?
Yeah, what would happen that?
On the disruptive consequences, I think I would distinguish this case from other cases where the court has been concerned about the idea of build something and then explain it later. And that's not the situation here.
But usually it has to be a circumstance in which at least the thing that was flawed can be rectified. Whereas here, the problem, my hypothesis, assuming that we don't accept your argument, obviously, it can't be rectified because it was in violation of law. It was in contravention of Section 401.
I think it's a harder case than the case where, say, if the error is an EPA related or the balancing under the Federal Power Act, it certainly. But again, this is not a case where I think we can all agree that the license here is an improvement over what existed before. The question really is from a 30,000 feet perspective, as petitioners are asking for even more. So,
well, no, all they're asking for, yeah, you're right. They're definitely asking for more. But in terms of the existing license, I just don't see how we can not vacate a license that's been issued in violation of law. Period.
I'm just concerned about the disruptive consequences.
But what's the disruptive consequence? It's not like someone's proposed to take the dam down, or this is a dam that's under construction, and we're stopping the construction. This is an existing operation, and people are just debating reasonably, apparently, over what the conditions are. And here's a license that's been issued in violation of law. I don't even understand what basis we would possibly have as a court not to vacate it.
I would just add to that, Judge Tatel, that under Allied Signal, the disruptive consequences that the flow regime, the operation of the dam itself, is a huge improvement over what existed before.
In the ex-ante world, there were just annual licenses that were being issued.
Yes.
Right? And so presumably, whatever the disruptive consequences you're concerned about are disruptive consequences for the environment.
Yes.
Totally understandably. And I take it that was also the case in a regime in which the annual license were. You also had those concerns, and something was being done to adequately address those on a year-to-year basis.
The annual license, correct? It would have continued basically the existing conditions from the previous license.
I mean, are you suggesting in response to my question? Let me make sure I understand. The 2018 license certification had a set of conditions. So also does the settlement, but those are less rigorous, right, than the 2018 ones, correct? That's why Waterkeepers is here.
That's correct.
Okay, so are you suggesting that if we vacate the license, the dam operator will cease the complying with the conditions in its own agreement?
I think part of what the license here is approval of a settlement, which would have a flow regime. And I'm concerned that a vacator of that approval.
Well, we can ask, they're going to argue here. We can ask them that question. Okay, we don't have to guess. We'll just ask. Great.
So my colleagues have further questions for you.
Yeah, thank you.
For
asking that the court from the orders. Okay.
Thank you. We'll hear now from Mr. May for the state. I believe 2 minutes allocated to you.
Appropriate height. May it please the court. As this court and others have recognized, Section 401 and the certification requirement it provides serves as one of the primary tools that Congress reserved states.
Reserved to states, it gave them a choice. You can impose conditions You can waive, we're not participating in the setting of conditions.
That's correct.
And what happened here is we want to impose conditions, but we're going to call it a waiver. That seems to me a door not left under the statute, because you are imposing conditions.
Well, the state initially issued a water quality
I'm talking about
certification
this.
in 2018. And following, I would agree with Your Honor's questions before, that the statute in the text does provide for affirmative waivers. Refusal to act is a form of waiver, and the state, although it initially acted, later, by entering into the settlement agreement, submitted to FERC a joint offer of settlement.
But it didn't refuse to act. It said, we would like to have these conditions imposed, and if you impose these conditions, then we will waive. That's what seems to me. The one thing a waiver isn't, whether express or not, is the imposition of conditions on the license.
In a certification, it's waiving the certification requirement. It's waiving the ability to have those conditions imposed in the license through a certification issued under the Clean Water Act.
What's the difference if you can get to it?
It was able to secure those conditions in a settlement agreement, which occurs all the time.
If you had done it through a certification, the statute would require you, as part of that certification, to confirm that the conditions comply with applicable provisions of the Clean Water Act 13, 11, 12, 13, 16, and 17. And your original certification did that in terms.
That's correct.
Of course, your settlement agreement doesn't say that the terms you now want to impose do comply with these provisions. And so isn't the concern with a waiver with conditions that it's a complete end run of Maryland's obligation to certify that the conditions it selected comply with these federal law provisions? Or did they comply with it?
The state has the authority, as this court recognized. It alone determines whether or not to certify, whether you use the power provided by Congress in Section 401. And the state has the authority to waive that.
When the state waives, just to follow up on Judge Millett's question, when the state waives but imposes conditions, and I take your point that the conditions that are being imposed are not a certification because you're waiving certification. They're conditions that are being imposed in a private settlement agreement with Constellation. Does the commission need to incorporate those conditions into its license?
The commission is not bound by the parties' settlement agreement. We presented the commission with the settlement agreement and offer of settlement and asked that they incorporate them as supported by the record before the commission. But the settlement agreement didn't directly impose any condition. It was a private settlement agreement between Constellation and Maryland. It did not become effective until FERC took the next step. And well, they agreed it was effective, but the parties, there were provisions and dispute resolution provisions in the event FERC did not take the ultimate step of incorporating the proposed license articles into the license. Had that not happened, then the state would have had a right to terminate the agreement.
So the commission can issue a license without regard to these kinds of conditions. In this situation, they could just issue a license without any conditions at all.
I'm not saying that. The commission would have to.
Why can't they?
Well, it has to follow the Federal Power Act, and it has
right,
to.
But what is it in the Federal Power Act that requires the incorporation of conditions that are part of a private settlement agreement?
No, I'm sorry. They're not required to incorporate those conditions. That's not what I meant. Yes. And FERC could have rejected our settlement. We presented to them. It was placed on public notice. There was a comment period.
So what is the status of the settlement agreement if we were to vacate the commission's license?
The settlement agreement is being implemented. The state did not take a position on the ultimate relief in the case, but I agree with what was stated in the Department of Interior's brief that there would be some disruptive consequences and certainly delay potential interference with implementing the environmental projects that are provided for by the settlement.
Well, why is that? Okay, so maybe I should ask Constellation this, but so under the settlement, there are provisions to deal with flow, fish, and eel passage, invasive species, and trash and debris. So if we vacate the license, are all of those measures going to stop?
It's a very good question. It depends on the reason for vacating the license. If the vacating the license includes finding that Maryland lacked the authority to waive.
No, that's not my question. We would vacate on the grounds that Maryland has not lawfully waived. That's it. I mean, Maryland would still be free. If all we did was vacate a license as opposed to requiring a new license subject to the 2018 conditions. All we did was vacate a license. Maryland would still be free to follow its normal procedures and eventually, presumably, if it wanted to, vacate the 2018 certification, and then I guess we just start over again.
Yes, if the 2018 certification.
So why would these protective provisions be abandoned in the meantime? The dam operator has agreed to them with Maryland. I mean, just because this court vacates the license, they say, okay, they vacated our license. We're not going to protect eels anymore. We're not going to worry about trash. We're not going to do any of this stuff. They're not going to do that, are they?
There were provisions. I'll speak for the state. Yeah. I can't speak for Constellation. However, there were provisions in the settlement agreement that tried to adjust for what would happen when FERC issued the license. It did not go so far as written in the settlement agreement as to what occurs should a FERC license be challenged. And
right, that's the question. So
that's what the question's all about.
Yeah,
we'll ask Constellation. Yeah.
But do you have a view? I mean, does the state have a view on what happens with the review? Because as I read the documents, they only talk about FERC's issuance of the license.
That's correct.
That happened.
That's correct.
So it's kind of like, it reads to me as if those are in effect, regardless of what happens on review.
And I don't want to predetermine the state's view on what would occur in that case.
What is FERC supposed to do in the meantime? This is what I don't understand about this. If the license is vacated, FERC, way more than a year has elapsed since the company applied for this license. Does FERC have to just keep waiting until the state goes through settlement process, administrative process, which could take years? What is FERC supposed to do? When can Constellation go back to FERC and go, we have nothing?
I think there is a risk that Constellation would do that. From the state's perspective, this was part of the underlying litigation. We disagreed with Constellation about how the finality of administrative review.
I know you think Constellation. So say it's just assume there's a vacatur, and Constellation says we've waited long enough. Okay, we've got nothing here from the state.
They already have a pending petition for declaratory order that was deemed moot because FERC issued the license. So I would expect them to make that argument. The state would argue.
Do you think they would be right under federal law to say to FERC?
No, because the state did initially act within the 1 year period in 2018 when it issued the license.
The certification.
The certification, sorry, correct. And although there's a tendency of appeals after that time, I do not believe that that would result in a waiver. And even the most recent decision from the Fourth Circuit suggested at least that act within 1 year does not even need to include a final decision so long as substantial progress has been made. And so the state's position would be that there would not be grounds for waiver. But
no, so if they went back to FERC, and FERC would have to adopt the 2018 certification before it could issue. It couldn't issue a license without adopting the 2018 certification.
Before the settlement was entered, the administrative appeal process was underway. We were in litigation with Constellation over the terms of the certification, and FERC waited. FERC waited for that to.
Does it have to keep? That's where I started this question. They have to keep
it's policy to wait, but I don't know that that means they have to.
Do they wait for just the administrative process, or do they have to wait for all the litigation?
That would be up to the commission, but I believe their general preferences for settlements and to allow that process to unfold.
But your view is that at least that they could continue to wait.
Yes.
Well, certainly they could continue to wait, but
yes.
If they didn't want to wait, if they didn't want to wait, then they would have to issue a license that includes the 2018 terms.
If MDE's waiver has been deemed ineffective and the 2018 certification is in place, then that is the only certification that they would have to rely on in issuing the license.
Or they could just not.
Or they could wait.
They could wait, withhold action until
it plays out. Correct. And the question of whether the state has waived, well, there's a federal question as to whether the statute provides for affirmative waivers, and it's our position that it does. But it's a question of state law as to whether the state acted properly and followed its procedures in issuing the waiver. The Sixth Circuit said that very clearly in the city of Olmsted Falls case. With the city of Tacoma case addresses that issue as well, is that the federal agency and the reviewing court don't look into that process to determine whether the waiver was proper. It's they rely on the affirmation from the state that it followed its own processes. It's a separate question
but it has to waive. It has to either not act or issue a waiver. It can't do. It doesn't have a third option. That's not up to the state, right?
No, I think it is.
It is?
The affirmative waiver is supported by case law cases. Courts that have examined the text of the act have not had a problem in finding that states have the ability to affirmatively waive. And federal
yes, I agree with that. Under the statute, the state can waive its rights under 401, right?
Yes.
But the question of whether it has or hasn't is a federal question. We interpret the statute, not the state. In other words, we don't have to defer to the state's judgment that what it did here in the settlement was a waiver, do we?
I think the case law suggested that the court does
really?
The state, that you don't conduct an in-depth review of the state procedures.
What in-depth review is required for us to conclude that a conditional waiver is not a waiver?
I think it's a question of whether the state has the power to issue that. In addition to the settlement agreement, I also want to point.
You have the power under state law. All we would decide is whether it's a waiver within the meaning of federal law.
Yeah,
that's a separate question.
Oh, you agree
we don't
with
defer
that?
to you on that. Obviously.
Oh, I'm sorry. You and I were talking. I take back what I said. You and I agree.
And can you just tell me one thing? The conditions that are in the settlement agreement, do they comply with the affluent limitations of the Clean Water Act listed in section 1341 or not? Because there was no such representation that I could find in the settlement agreement.
Yeah, the settlement agreement does not contain any such statement. It's a settlement.
Yes, but do they comply with do the terms comply with the affluent limitations or not?
There's no finding in the record that Maryland.
Does Maryland believe that the settlement agreement was consistent with federal law, or did it violate the terms of the Federal Water Act?
It does. Maryland does not believe that the settlement agreement violates federal law.
Including these, so you believe it's consistent, the terms that are in there, put aside this issue we're talking about a waiver, that the terms and conditions that are included in the settlement agreement meet the affluent limitations of the provisions of the Clean Water Act listed in section 3041.
Maryland has not made that finding in the record. What Maryland has done is.
I'm not asking whether you made the finding in the record. I didn't see it in the settlement agreement either. I'm asking whether the settlement agreement did or didn't. That's just a federal law question. Did your settlement agreement comply with the requirements of the Federal Water Act or not?
It did not need to comply with the federal act and
So we don't know actually then whether the conditions comply with these affluent limitations, which the statute makes a condition, requires that any state conditions imposed under 1341 meet these limitations.
The state was using its authority under section 401 to impose those conditions in a federal license. It would have, the record would have to include those findings.
So, but if you want to impose conditions, a state hypothetically wants to impose conditions, but it doesn't want to have to meet the affluent limitations of the statute, the way you do it is to do a settlement agreement and get around this requirement if you were to be upfront about a condition imposition.
The state has an ability to waive its section 401 authority. And so
yes, but waivers under the statute, a waiver is a decision not to impose conditions, but you have now come up through the settlement with a way to impose conditions, assuming FERC goes along, a way to impose conditions without meeting the statutory prerequisite for conditions.
Because we're not using the section 401 authority to impose those.
Right, and that's why FERC doesn't actually have to incorporate the conditions into its federal license at all in this circumstance.
Does FERC have to find that they comply, that the conditions comply with these fluid limitations of the Clean Water Act before it can incorporate them?
FERC did not need to make that finding. FERC had to make a finding that
Is that finding supposed to be asserted by the state when conditions are imposed?
through water quality certification, that's correct.
But you don't have to make that affirmation when it's not a certification.
That's correct. Yes.
Yeah, because you could, in other words, what you're saying is we could have waived all along. We could have just refused, and we could also entered into a side agreement.
Yes.
We just did that. Just collapsed it into one, and we said, we're waiving and we're entering into this agreement.
Yes, that's correct. On receipt of an application, the state could issue an affirmative waiver. I know my time is way over, but I just did want to point out the joint appendix 588 is the joint offer of settlement and explanatory statement that was presented to FERC, and that contains the conditional waiver by NDE in addition to what was pointed out in the settlement agreement.
Thank you.
Thank you.
Mr. May, Mr. DeBruin, we'll help from you now for, we have 3 minutes. Yes.
Thank you, Your Honor. May it please the court, David DeBruin for Constellation. I think it's very important to start with the legal framework.
Wait, before you do that, could you just answer the question we've been asking everybody else, but you are the only one who probably knows the answer, which is if we were to vacate the license, would Constellation continue in place these provisions to protect eels, fish, and things?
And Constellation certainly was previously under an obligation to protect the environment under the interim licenses.
Yeah.
It would go back to those interim licenses, and absolutely, Constellation would take all adequate measures to protect the environment, the fish, the eels.
Right.
I think it's important for the court to understand the context.
Hey, can I clarify your answer? You said you would go back to the terms of the prior license. Does, under this settlement agreement, are the terms for protecting eels and other fish more protective than they were under the annual license that was being issued before?
They were.
They were. And so if this license is vacated, when you said we'd go back and we would protect the environment, are you going to protect it under the terms of the old license, or are you going to continue to protect it under the terms of the settlement agreement?
So several things there. First, I think this court clearly has authority, even if it were to reverse, which I will argue in a minute, there is no reason to do, that this court does not need to vacate the license, even in cases in which it finds a violation of law. And I can cite you 3 cases that this court has decided, including recently, that has found that a remand without vacatur is appropriate, even in cases where it finds a violation of law, in order to leave in place an environmental scheme that is more protective. So the situation
I was just
was,
asking what the company would plan to do. Would it go with would it continue with the settlement terms for protecting fish, or would it revert to the terms under the 1-year license, the annually renewed 1-year license?
we don't know what the court's order says. We don't know what the commission, we operate.
Assume there's no order, it's just a vacature of the license. I'm asking you what is a matter of what I think I'm trying to ask you what Judge Tatel was asking, and that is
same question.
the company can choose either of those paths. It would have to, at a minimum, do the 1-year license.
There was a settlement agreement that included a number of provisions, including significant reductions in the flow regime, which is the way the company is able to make money by operating a hydroelectric plant. So I cannot say, without knowing what the court does, whether we're going to pick and choose and impose obligations on the company while at the same time.
Okay, well, it's a simple question. We'll tell you what the court's going to do. Assume the court vacates the license. But just a hypothetical. Just assume we do. Is the company going to stick with the flow requirements in the settlement agreement, or is it going to return to the flow requirements in the 2018 license?
I cannot answer that. I can tell you that I
thought you said you could answer it if you knew what our options were.
Well, if that is your option, I cannot tell you what the company would do or be required to do.
Okay, why don't you give us, what are the 3 cases that you want us to look at?
And just to be clear, these are 3 cases that stand for the proposition that we can remand without vacature.
Even if it's
You
in
can
violation
remand
of
without vacature, even if you find
what are the 3
violation
cases?
of law.
What are the 3
North
cases?
Carolina versus EPA, 550 F3rd 1176.
Okay.
U.S. Sugar Corp versus EPA, 844 F3rd 268. American Great Lakes versus Schultz, 962 F3rd 510.
Can I ask this question? Some of the questions are presuppose that the company would choose whether in the event of a vacator of the license, the company would choose whether to revert to the last annual license or the settlement agreement. My question is, does the company have a choice, or did the settlement agreement already kick in because the license issued? So it doesn't matter what happens on judicial review. The settlement agreement is actually operative.
But the settlement agreement imposed a series of interrelated conditions. If certain conditions limiting flow and other provisions were incorporated into the license, the company in turn agreed to a series of provisions. But ultimately, the company operates pursuant to a license that is issued by FERC. So if this court were to vacate the license, we have no legal authority to do anything unless and until FERC issues a new license. In the past, when our long-term 40-year license had expired, FERC addressed that problem by issuing interim licenses that continued on an annual basis. I'm presuming that if this court were to vacate a license, which it should not do legally, and even as a remedy need not do, that the commission would have to decide what license to reimpose, and I presume they would reimpose the interim license. We would have to look under the terms of that interim license how to operate.
So there's no room, in other words, for a separate agreement on top of the FERC license under which the company undertakes additional protective measures.
Possibly, Your Honor. First and foremost,
but if that's possible, then why isn't that this case? Why doesn't the settlement agreement just do that?
Well, because there could be inconsistent provisions between what FERC is requiring and what, and I'm not going to stand here and say, without looking at the agreement, what company may or may not do.
But is that conceptually possible? That if it's not inconsistent, I take your point about inconsistent. You can't have things at loggerheads.
It is conceptually possible that the company could voluntarily choose to do things above and beyond what its license.
And that it already has by entering into the settlement.
Possibly. I don't read the settlement agreement that way. But
why don't you?
Well,
what is it that tells you
the
that
structure of the settlement was a combination of provisions, including the company took the position that Maryland had waived by failing to act over the course of many years, which we raised essentially a Hoopa Valley type argument. Mm-hmm. That was one of the very significant legal risks Maryland faced, and Maryland chose to enter a voluntary settlement of its rights, which is a bedrock fundamental legal principle. The parties who have legal rights can waive those rights, and that essentially the company then agreed to withdraw the Hoopa Valley challenge if FERC accepted the party's offer of settlement, which is a very common procedure at FERC. Parties propose offers of settlement to the commission all the time. FERC is not obligated to accept those offers of settlement. FERC has its own both power and responsibility under the Federal Power Act to develop the waterways of the nation for use of clean, renewable electric power, but also to protect the environment at the same time. And Congress said in the Federal Power Act that FERC shall give equal weight to those two goals: develop the waterways for use of clean power, check the environment, and FERC issues license accordingly. So we proposed terms to FERC, and it was up to FERC under its own discretion under the Federal Power Act to accept them. If FERC did that, Maryland agreed it would waive. And I'd like to, if I have, before my time runs out, provide the court what I think is a critical legal framework for this case, which is why Section 401 clearly allows Maryland to affirmatively waive, even though there's nothing in the text of 401 itself that addresses an affirmative waiver. But as I'm sure this court is familiar, courts read text in context and with a view to their place in the overall statutory scheme. And as the Supreme Court held in the Marks case that we cite, quote, background presumptions are a highly relevant contextual feature. Here, there is a firmly established background presumption, and I quote from this court, that statutory rights are generally waivable unless Congress affirmatively provides they are not. And that's the Price case, also the Supreme Court
But you
case.
see, all that does, I know that case, but that just begs a question. In this case, of course they're waivable. The question is whether this statute limits the waiver to the two circumstances in the statute.
So two things, Your Honor. Yeah. First of all, I don't mean to interrupt.
That's okay. You answered my question. Go ahead.
What the text of 401 is addressing is not waiver at all in the traditional sense. Mm-hmm. Section 401 sets a condition of forfeiture. As the Supreme Court has said, and this is the Alano case, quote, waiver is different from forfeiture, whereas forfeiture is the failure to make the timely assertion of a right. Waiver is the intentional relinquishment or abandonment of a known right. In 401, Congress imposed a statutory condition of forfeiture. If the state fails or refuses to act within 1 year, and I submit that that statutory text, fails or refuses, does not encompass an affirmative waiver, that Congress imposes a forfeiture. A failure to act within 1 year is a forfeiture. And in this case, Congress went further and treated it and called it a waiver in the sense that unlike most forfeitures, which may be excused, waivers, a knowing intentional relinquishment of a right, is not excusable. There is a difference in various contexts between forfeiture and waiver. Under the plain error rule, certain rights can be, plain error can be waived, but plain error cannot be forfeited under Rule 52. So there is a difference. This statute is talking about a situation of forfeiture, clearly. It calls it a waiver because it doesn't intend for there to be a way for the state to excuse it. No part of this statute is dealing with waiver. The background principle that rights are generally waivable unless Congress says otherwise. Congress did not say otherwise in this provision of 401 that these rights could not be waived. When Congress intended for rights not to be waived, it said so. It said so in section 403, just 2 provisions later. There is nothing in this statute that is addressing waiver. The first and the second sentence that you were focused on, the first saying that a state that fails or refuses to act within 1 year, the right shall be, they use the word waiver, and FERC cannot proceed unless.
What's the limit on waiver if that's reading of the statute is right, such that it doesn't touch waiver at all? Even though it calls it waiver, it's really dealing with what we traditionally think of forfeiture. Of course, we know Rule 52 and all that. What's the cap on waiver past certification?
So rights traditionally can be waived even after they're asserted. So we all know a defendant frequently asserts a right to trial.
Right, so is there any limit?
There is no limit beyond the typical requirements of waiver, which typically is that a waiver be knowing and voluntary. Yeah. And in fact, the petitioner's argument today, frankly, makes no sense.
What if FERC issues a license?
Well, that is an interesting limitation.
So it is a limit.
Well, yes, in this sense. So the statutory scheme is set up in such a way that any federal agency, including FERC here, cannot issue a license that involves a discharge into navigable waters unless there has been either a certification or forfeiture or, pursuant to the background statutory presumption, a waiver, which is within any party who has a statutory right to waive unless Congress says otherwise, and Congress didn't here say otherwise. Once FERC issues a license, the state's 401 powers are essentially over. And at that point, FERC has issued the license. It can modify the license, but the license is within FERC's control. Now, FERC has said as a matter of practice that when state proceedings are ongoing, either state administrative proceedings as here, the state administrative agency itself had not even finished its process. It had issued a certification prior to trial, subject to reconsideration. All of that remained. FERC has said if state processes remain, it will exercise its discretion, typically, to adopt changes from that process and modify the license. Again, FERC has the power at any time within 50 years to modify its license upon an application of any party.
Okay.
But legally, upon the issuance of a license, the 401 power of the state has been eliminated. FERC has now issued the license, and it's up to FERC to change it. Okay. But what is critical is that the power that 401 gives to the state, which is a very significant power, is the state's power. And like any right under any statute, background principle, the state can waive. It's no different than under 1983, which says every person who deprives another by color of state law of a constitutional right may be found liable. Absolute sentence, every person. And yet the Supreme Court in Imbler and other cases has recognized the background principle is there are immunities, there are absolute immunities that judges, prosecutors, and others cannot be found liable under 1983. Why? Because that's what the text says? No, because that is a background principle.
Let me make sure my colleagues don't have additional questions for you.
Can I just address, well, I guess I have addressed the remedy point. Again, because the court has, I don't believe there's any need to consider remedy here, but because the court has raised it, I do believe under the authority, because a vacatur of the license would be disruptive, the environmental benefits of the current license above and beyond the previous license, the court can and should at most remand without vacatur and because not only would there be environmental disruption, but I submit to you that as the petitioners can see, we can get to the same place as we are now, apparently under adherence to a state process that they concede we can do. I submit that's exactly what we did do. We adhered to a state process. We settled a petition for reconsideration. I don't know what more, but in any event, we can go back and come to the same place as we are today.
Thank you. Thank you, Mr. DeBruin. Mr. Beese.
May it please the court. John Beese, here representing the Department of the Interior on behalf of the Fish and Wildlife Service. Congress enacted Section 18 of the Federal Power Act to protect the environment when hydroelectric power plants are built, to ensure that they don't harm the environment by interfering with the passage of fish, migratory fish, up and down river. The Conowingo Dam was built in the 1920s, 10 miles from the Chesapeake Bay, on the Susquehanna River, which is the largest watershed on the eastern seaboard. The dam, along with other factors, has harmed the population of American shad, river herring, and American eel, which play an important role in the larger aquatic environment, both as prey and in promoting the growth of mussels that filter the water, and also have been important to human endeavors in the past for recreation and for food source. Sadly, the populations of those fish have been severely diminished by, among other things, the dams on the Susquehanna River. Before the 1921 license, the dam included 2 fishways, one built in the 1970s, one built in the 1990s. But the study and research done in connection with the pre-application process for this license, beginning in 2009, showed that they were inadequate to protect the healthy population of these fish. And through the Fish and Wildlife Service engaged in years of effort, including research and scientific study, working with the company and drafting language for prescriptions, it culminated in the April 2016 settlement and modified prescriptions that can help improve the population of these fish in important ways, including a trap and transport program that the company agreed to implement that moves the fish from below the dam, some of them all the way above all 4 dams, the upper Susquehanna, through some structural improvements to the 2 lifts that are significant investments of resources and are staged based on the date of the license. So the obligations to make certain corrections take place a number of years after the license is issued.
So you don't want us to vacate the license, right?
So,
you don't want us to vacate the license, right?
If you were to vacate the license entirely, it would mean all of these protections would be gone, including the significant infrastructure changes to the lifts. And in response to your Honor's questions earlier, well, the annual licenses that presumably would fall back into place if the license was vacated might include some protections. Historically, they interpreted that.
Well, they would be protected if we did what Waterkeepers wants, right? Vacate the license in order to issue a license based on the 2018 certification, correct?
That would delay the process for which all these infrastructure changes would be made.
Why?
Because they're keyed off the date of the license issuance. So the company's obligations to make the changes to the West Fish Lift and the East Fish Lift would be.
No, I'm sorry. Aren't the 2018 provisions, aren't the conditions in the 2018 certification more rigorous than the ones in the settlement agreement?
There are some additional features for fish passage in the MDE settlement that weren't in the modified prescription that Fish and Wildlife reached, but the important one changes from services perspective are these important infrastructure changes, which I think would be delayed if
Well, where did they come from? Did they come from the 2018?
they come from the modified prescription that the service implemented as part of the license through their April 2016 settlement with the company, and then FERC approved the modified prescriptions that are in appendix.
But your point isn't that the settlement agreement actually is less protective than the 2018 certification. Your point is not based on the relative protective degree. It's based on the temporal dimension, that actually the trigger date is delayed if you go back to the 2018 instrument, because we'd be issuing the license on a particular date, and then the timeframes would only kick in at that point.
Yeah, the obligation of the company to make the infrastructure changes is keyed off the date of the issuance of the license. So if this license is vacated, and the new license is issued, it would affect.
So even if they're more rigorous, even if they're more protective measures, they take longer to come into effect.
Right.
That's your point.
Even assuming that the new license incorporated the same prescription for fish passage.
As the 20th. Okay. Make sure my colleagues don't have additional questions for you.
No. Thank you, Your Honor.
Thank you, Mr. Beese.
If I could just conclude, we think that the court has discretion to be cognizant of the concrete realities on the ground here, that the dam is there, the fish are there, these measures will protect them. Thank you.
Thank you, counsel. Mr. Pugh, I think we're back to you now. We'll give you 3 minutes for your rebuttal.
I'd just like to make a few points. The first one is about the idea of permanent waiver, and we've discussed that before. I just wanted to mention, I want to make sure I provided a citation to EPA's regulations. EPA is actually the agency charged with implementing the Clean Water Act, and its interpretation of Section 401 does get deference. And what EPA said in affirmative waiver is a decision not to act on a request. It's not what FERC and Maryland are talking about. The next point I'd like to make is very briefly about the idea that the state process hasn't finished, and the concession my colleagues suggested we made that they could get to the same result. The reason the state process hasn't finished is that Maryland and Constellation abandoned the process before it finished. I would add that we don't concede anything of the sort. We think that if this process was followed properly, Maryland would have to reach a different result. And if it came to the same, if it concluded that all the things that it said are necessary to protect the Chesapeake Bay and the Susquehanna River are not necessary, I think we would have some very strong arguments that, well, first of all, we'd have to explain it to the public, which I think was very important. And second, I think we would have some very strong arguments that it was acting arbitrarily.
Could you weigh in on this remedy question for us?
Pardon me?
Could you say something about this remedy question? The Interior Department says that if we, I understand what you want. You want us to vacate and order FERC to issue a license based on the 2018 conditions, right? Correct?
Yes.
Okay. But do you agree that if we just vacate and nothing else, that the protections for fish will revert to the interim license, which aren't even as protective as the settlement?
I don't know. I do think that's a possibility. But I guess make a couple points on that. One is, there can't be a more fundamental violation of the Clean Water Act than doing something that the Clean Water Act expressly precludes, forbids. And that's what happened here. So that's I think, a very important prong of the outline. The other thing to remember on disruption is this is a 50-year license for the dam. This is what's going to decide what happens to the Chesapeake Bay and the Conowingo River for the next half century. And it's important to start getting it right. And this, neither the old license nor the settlement even come close to doing that. What's missing from them, what Maryland found necessary to protect the bay and the river in its certification are very large reductions in the dam's discharges of nutrients, over 6 million pounds a year, allowing millions more fish to pass the dam than do now. Providing far more flow for the fish to survive below the dam, and providing for eel passage so that the mussel population, which has been wiped out can be can be restored, and the mussels can start cleaning up the water again. So,
how many years is it going to take to get to this point? Right? They've still got if it's vacated, they've still got administrative processes and other things to go through, and then I just don't know how long it's going to be, and how many fish are going to be left by the time we get around to a new license.
I mean, that's why, frankly, we think it would be more helpful to just issue the license with the certification in it. We also think that would be appropriate under the statute, but
But suppose hypothetically we don't do that. I mean, you brought this case because you're seeking to protect the quality of the water and the fish and animals that live there, right? So if your only option is between two options, vacating the license or leaving or remanding without vacature, which do you pick in terms of your goals in this case?
Vacature, because this is a 50-year decision.
I see. So you think maybe even though there's short-term loss of protections because the company might return to the interim license, that in the long run, that's better for the quality of the Conowingo Lake and everything, right?
That's right, Your Honor. The only way to get this license right is to start fixing it, and the only way to start fixing it in a way that does comply with the law.
Okay.
It's a matter of law. If FERC issues these interim licenses, does it have the ability to impose new conditions on an interim license, or can it only carry forward what happened before?
I believe FERC has authority to impose conditions beyond those in the license, beyond those in its own license, what it wants to do to protect the water quality.
Because each annual license is a new license.
Each annual license is a new license, and it has federal power.
Could it impose these settlement terms on its interim license? Could it impose these same settlement terms as part of its interim license?
I believe so.
And just keep doing that for years?
Well, I don't know about keeping them in that.
Probably not 50 years.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.